Have you ever missed a deadline for an assignment or a task and tried to make up an excuse to cover that you might have just been procrastinating or buried by life outside of school or work? And have you ever forgotten to pay a fine or a bill on time because your life has just been so stressful and you're financially stretched? Have you ever lied in order to avoid disciplines because you think it's not a big deal? You might think the scenarios above sounded familiar and these matters were somewhat trivial, and oftentimes you might be able to get away with it without any consequence or guilt in your mind. But what happens if you're a practicing lawyer? Mr. Peter Quintominas has been a practicing lawyer for over 20 years since 4th of July 1989. On 22nd of November of 2017, an order from New South Wales Civil and Administrative Tribunal has found Mr. Quintominas guilty of professional misconduct on two grounds. He was subsequently ordered to pay a fine for $6,000 in total and the legal costs of the applicant in the amount of $50,000 in the disciplinary decision made by the tribunal on the 21st of August 2018. What happened there? Mr. Quintominas held an unrestricted practicing certificate from 4th of July 1989 to 9th of July 2010. On the 13th of August 2010, the New South Wales Bar Council imposed a condition to his practicing certificate which required him to pay all of the tax owed to ATO on time and submit quarterly reports of his financial and medical statement, and attend treatment sessions with his psychologist, Mr. David Goldman. However, between 12th of March and 30th June of 2015, Mr. Quintominas has not complied with the conditions in several occasions where he misled the council to believe his 3 quarterly BAS were lodged and paid on time in his quarterly reports, when in fact he did not pay any of the BAS until 13th of July 2015 when he paid in full altogether. He also only attended one session for his treatment with Mr. Goldman and has not returned to the treatment sessions ever since, even though Mr. Goldman has emailed him with reminders of their appointment in several occasions before and after the scheduled date for their second appointment. On the 13th of June 2016, Mr. Quintominas applied to the council for his practicing certificate for the year of 2016 to 2017. But the application was rejected by the council on 11th of August 2016 on the basis that he was not a fit and proper person to hold an Australian practicing certificate due to his false and misleading statements in his reports and his failure to comply with the conditions. The council subsequently applied to the tribunal with 2 grounds in relation with findings, whether Mr. Quintominas' conduct amounted to professional misconduct in ground A by misleading the council in the emails he sent to the deputy director of the council, and whether he engaged in professional misconduct or at least unsatisfactory professional misconduct in ground B by failure to comply with the conditions imposed on his practicing certificate. There are 2 key ethical issues raised from this case. The first being repeatedly misleading the council in his quarterly reports, which constituted professional misconduct because his conduct would be regarded as dishonorable and disgraceful by barristers' peers of good repute and competency. Even though his conduct did not occur during practicing, it was accepted by common law that professional misconduct may extend to conduct occurring outside of practice, which has a sufficiently close connection with the actual practice, and the conduct outside practice that shows the presence of qualities that are incompatible with or the absence of qualities that are essential for the conduct of the practice. The second ethical issue is in relation to Mr. Quintominas' failure to comply with the conditions imposed on his practicing certificate, and the key issue here is whether his conduct amounted to professional misconduct or just unsatisfactory professional conduct. Since his breach of conditions was an undisputable unsatisfactory professional conduct, the key difference between these 2 conducts is whether the continuous breach of conditions amounted to a substantial or consistent failure of unsatisfactory professional conduct. The tribunal decided on the fact that even though his failures were remedied in a short period of time with a relatively small amount of money owed, comparing to other cases discussed in the judgment, it still constituted professional misconduct under Section 297(1)(a) of the LPUL. But what were the reasons that led to his misconduct and the factors that influenced his behaviors? Mr. Quintomina's counsel, Mr. Molumby, submitted a list of evidence of Mr. Quintomina's mental state. However, they were disregarded by the tribunal, partly due to the seriousness of his breach. From the limited facts of this case, we were unable to determine whether it was the environment that Mr. Quintominas had been in that contributed to the misconduct, or was it himself as a bad apple in the situation, according to Robinald and Sterlite's behavior legal ethics. Nonetheless, given that Mr. Quintominas' mental health condition was part of the contributing factors, regardless whether his evidence submitted was convincing or not, he was most likely impacted by his lack of ability to consider the consequences of his actions and failure to seek consultation, especially his psychologist, Mr. Goldman.
Let's start by analyzing whether the judgment was fair. This judgment uses common law and statutory properly and logically, which amplified and reaffirmed the tribunal's role to protect the public, not to punish the lawyer. The tribunal makes separate decisions in relation to ground A and ground B. As for ground A, in the judgment, the tribunal compared Quintomina's conduct with a criminal. The tribunal agreed Quintomina's action was less serious as the amount of tests owned was lesser. However, the judge did not conclude ground A as simply an unsatisfactory conduct. Rather, the nature of misleading the counsel was deemed as a serious indication of incompetence, which is dishonorable and disgraceful for a barrister, which amounted to professional misconduct. Mr. Quintominas has also admitted to misleading the counsel in his letter. Thus, the decision on ground A is undisputable. In the reasoning for the decision in regard to ground B, the tribunal did not take Mr. Quintomina's personal health into account while assessing whether Quintomina's conduct constitutes professional misconduct. The judgment concludes Section 2971B was an objective test. Therefore, respondents' personal health and subjective state of mind were irrelevant, and they disregarded all the evidence in relation with Mr. Quintomina's health conditions submitted by his counsel. The decision for ground B found Mr. Quintomina guilty of professional misconduct, shows the public that there is no excuse for lawyers' misconduct in that circumstances. Another point to make this a fair judgment is the tribunal did not try to punish Quintominas. This can be seen from the fact that the tribunal made a separate judgment on each ground separately rather than combining two grounds. One breach might not attract removing from the role, but two breaches might be serious enough. However, Mr. Quintominas was not removed from the role. The tribunal simply reprimanded his license and ordered a fine, which shows the tribunal's power was exercised appropriately. Next, let's move on to the mitigating factors in this judgment. There are three factors in this case. The first one is the respondent's health condition. The second one is his proper professional service. And the last factor is his unblemished record of practice from 1988 to 2010. The tribunal did not consider his health issues as they only assessed the objective seriousness of his conduct. The tribunal did consider his record of practicing and the quality of his legal service in the decision-making process. This could indicate that mental health condition weighs lightly in the findings of professional misconduct. Moreover, a lawyer's ability to give professional legal advice is an important factor to save a lawyer from exclusion. Now, we will move on to how did the lawyer handle the disciplinary process. During the process, Mr. Quintominas showed great remorse regarding his misconduct in the letters he sent to the counsel. He did not try to argue innocence in the hearing, rather he apologized for his non-compliance and ratified his failures immediately. Lastly, let's consider more detail by referring to admission and readmission rules. The fit and proper person test appears both in admission rules and legal uniform professional rules. The current judgment demonstrates the difficulty to prove a lawyer is not a fit and proper person. Quintomina's arguably had bad intention to dishonestly mislead the council. However, as long as he apologized, the tribunal will decide he is not a fit and proper person. In contrast, to prove a law student is not a fit and proper person is easier under admission rule, as academic misconduct can result in a failure to prove a good flame and good character. It is understandable that the law imposes a high threshold for character tests to gatekeep the legal profession, but practically the court tends to protect lawyers' good character and good fame rather than law students and judges.
In the case of ROG, OG has been struck off the roll since he was found to have plagiarized in an assignment back in law school. OG's behavior was objectively serious, as he failed to disclose and tried to twist all the blame to his friend. However, different from the current case, the court does not consider OG's good record as a legal practitioner nor his excellent academic result as a law student. The court concludes OG was not a fit and proper person according to his failure to disclose, and thus he was excluded from the role. Moreover, in Enfield, a retired judge is guilty of professional misconduct because he intentionally misled the court to believe he was not the driver who contested a speeding ticket. He is sentenced to 3 years in prison for knowingly making a false statement and has been removed from the role. Again, the court focuses on analyzing Enfield's dishonesty and mistakes rather than his contribution as a legal practitioner. From these two cases, we can see the court takes honesty as a dominant factor in deciding whether a person is a fit and proper person for the bar. However, this approach might have different effects on law students, judges, and lawyers. If Quintomanes did not admit his failure, would he then be removed from the role? The answer is not likely. But if a law student or a judge behave dishonestly, they would highly likely be determined as not a fit and proper person. Now we are moving to how the use of an ethics decision-making framework could change. In this case, the tools of ethical decision-making in Queensland Law Society's Ethics Centre could be used to avoid ethical mistake, particularly with consultation and guidance. We believe that under this circumstance, Mr. Quintomanes was aware of his unethical conduct because he has been a practicing lawyer for 20 years, and he did an excellent job as a lawyer. The reason he made his mistake is likely because he did not consult with anyone after he acknowledged the ethical issues. This can be seen from the fact that he sent the misleading email to the council on 20th July but made the apology statement on 29th July. What happened during these 9 days? What made him realize he was wrong? There is a high probability that he has consulted with someone during these days, like his counsel, Mr. Malaby, or his peers. What if he talked to his friends before 20th July? Perhaps he could have avoided the ethical professional misconduct in the practice. Additionally, he should consider the consequences of his behavior before he made the decision. It is obvious that the misleading emails and his inability to comply with the conditions imposed have a significant adverse effect on his career. He failed to consider the consequences of a series of inappropriate actions and was also too confident about the outcome of his improper conduct, which led to the judgment of his professional misconduct.